Streets dressed to scowl, tensions in the air, whisper sharp and foul. No armor, no cape, just me and these kicks. Guns pop, knives clink, I'm dodging all the tricks. I got this, head steady, head high in the mist. I got this, no fade, no slip, no twist. Crowd screams, sirens sing, still I persist. I got this, the whole town resists, but I exist. Protesters march, they chant loud and stark. Truth frayed like a thread caught in the dark. Front lines a jungle, survival the art. Every little step just trying to play my part. I got this, hand steady, head high in the mist. I got this, no fade, no slip, no twist. Crowd screams, sirens sing, still I persist. I got this, the whole town resists, but I exist. Middle fingers to the chaos, middle fingers to the lies. Knives out, but my spirit sharper than they realize. I'm the calm through the panic, breathe slow, chill vibes mounting in my chest. Steady heartbeat thrives. No game too tough, no climb too steep. Impossibly mundane in a world knee deep. Through the cracks of despair I plant my seed. Root strong, I control destiny's speed. I got this, head steady, head high in the mist. I got this, no fade, no slip, no twist. Crowd screams, sirens sing, still I persist. I got this, the whole town resists, but I exist. No game too tough, no climb too steep. Impossibly mundane in a world knee deep. Through the cracks of despair I plant my seed. Root strong, I control destiny's speed. Got this, got this, got this, got this, got this, got this, I exist. Got this, got this, got this, got this. Whole town resists, but I exist. The whole town resists, but I exist. Whole town resists, but I exist.
All right, it was quite a bit less than what I thought it would be in order to get this done. Just to let you know the truth, that's the truth. It was quite a bit less than I thought it would have in order to get this done. I know it's a little bit overdone. I'll admit that. Let's go ahead and bring this up. And like I said, I admit, that it's overdone. It's supposed to be. There it is right here. Here you go.
County Court, Larimer County, Colorado, 201 LaPorte Avenue, Fort Collins, SCO 80521. The people of the state of Colorado, Plaintiff v. Case No. Rex Fredrickson, Division, Defendant. Courtroom motion to dismiss. Failure to state an offense and lack of evidence of unlawful intent. Part 18-9-1-111 CRS R. Crim P. 12B2. Comes now the defendant, Rex Fredrickson, pro se, and respectfully moves this court to dismiss the harassment charge filed against him pursuant to Colorado Rule of Criminal Procedure 12B2 and constitutional due process protections. This motion is based on the insufficiency of the charging document, the absence of the statutory element of intent to harass, and evidence submitted by the state itself that affirmatively disproves criminal intent. I grounds for dismissal. 1. Defendant is charged under Paragraph 18-9-111E CRS, which requires that the accused, with intent to harass, annoy, or alarm another person, follow or repeatedly approach another person in a public place. Intent to harass is a specific intent element and must be affirmatively supported by the facts in the complaint. 2. The state has failed to file a valid charging document within the required time frame under Rule 4 and Rule 7 of the Colorado Rules of Criminal Procedure. Defendant has not received a summons or complaint that properly alleges the essential elements of the offense or states how the conduct was unlawful. The lack of a properly signed and timely charging instrument is fatal to prosecution. 3. Even assuming arguendo that a valid complaint exists, the materials in the state's possession, attached here as Exhibits 1 and 2, directly undermine the required mental state of the charge. The Fort Collins Police Report, Exhibit 1, and corresponding dispatch log, Exhibit 2, describe defendant's conduct as related to service of process following a court appearance on October 20th, 2025. 4. The report acknowledges that defendant was attending a scheduled hearing and followed the complaining party to the police department, believing he would accept service. At no point does the officer allege that the conduct was threatening, hostile, or intended to cause alarm. No obscenities, threats, or alarming conduct were alleged. The factual narrative, written by law enforcement, contains no inference of unlawful purpose or behavior. 5. In People v. McClelland, 204p3-1238, Colo App, 2009, the Court of Appeals held that conduct without the specific intent to harass, annoy, or alarm, even if subjectively unwanted by the recipient, does not satisfy the requirements of Paragraph 18-9111. Similarly, in Dillard v.'s Industrial Claim Appeals Office, 121p3-301, Colo App, 2005, the court affirmed that mere annoyance or misunderstanding of intent cannot substitute for the statutory mental element. 6. Additionally, the same set of facts was previously adjudicated in a civil action brought by Robert Thayer in this same courthouse. That case was dismissed for lack of evidence under the civil standard of preponderance, 51% confidence. If the facts fail to meet that lower burden in civil court, they logically and legally cannot support guilt beyond a reasonable doubt in criminal court. See also People v. Summit, 132p3d-320, Colo 2006, discussing comparative burdens in civil versus criminal claims. Exhibit 3, Civil Case Clerk's Docket, Thayer v. Fredrickson. 6a. The same factual allegations giving rise to this criminal charge were previously raised by the complaining witness, Robert Thayer, in a civil action in this court, Thayer v. Fredrickson. That case was dismissed on the merits for failure to meet the burden of proof under a preponderance of the evidence standard. As the civil burden is significantly lower than the criminal burden of beyond a reasonable doubt, it follows that the same facts cannot sustain a criminal conviction. The inability to prove civil liability necessarily implies that criminal guilt cannot be shown under Colorado law. See People v. Taylor, 159p3d-730, Colo App, 2006. Defendant hereby incorporates by reference his previously filed notice of similar cases as part of this motion to ensure the court has full context of the procedural and factual overlap. 25c-7. The charging documents and police narratives taken in the light most favorable to the prosecution still fail to allege any facts that constitute criminal harassment under Colorado law. No allegation describes actions done with the intent to cause emotional distress, fear, or annoyance. No repeated conduct is alleged, nor any verbal exchange indicating hostility or improper purpose. 8. The First Amendment also protects the peaceful attempt to serve court documents, and efforts to pursue judicial remedies are constitutionally protected conduct. Criminalizing this without clear intent to harass would chill the right to petition under NAACP v. Button, 371 U.S. 415, 1963, and McDonald v. Smith 472 U.S. 479, 1985. 2. Wherefore relief requested. For the foregoing reasons, defendant respectfully requests that the court A. Dismiss the charge of harassment under paragraph 1891 Lev 1 CRS with prejudice. B. Strike the matter from the trial docket. And C. Grant such other relief as the court deems just and proper. Dated this day of with prejudice, 2026. Respectfully submitted, X.
There you go. So, I don't think I have too much of a problem with this harassment charge. You all have a good one. May God be with you.